Namaskar and a very good afternoon to everyone. In the words of an eminent Dutch historian, Johann Huizinga, no other discipline has its portals so wide open to the general public as history. And on this note, we now proceed towards the end of the 3 days National Conference on Judicial History and Archiving, which is a part of the 75th year celebration of the Honorable High Court of Orissa. I, Srishti Samanta, Judicial Magistrate First Class, Odisha Judicial Services, and
I, Siddhant Mishra, Judicial Magistrate First Class, Odisha Judicial Services,
on behalf of the Honorable High Court of Orissa, extend our warm greetings to all the honorable dignitaries in the valedictory session.
we are fortunate to have amongst us Dr. Justice Muralidhar, Chief Justice Court of Orissa, respected Professor Kishore Kumar Basa, Chairman, National Monuments Authority, Honorable Judges of the High Court of Orissa, delegates, discussants and paper presenters, participants, officers of registry, officers of Odisha Judicial Academy, judicial officers and members of print and electronic media. We are privileged to have amongst us on the dais Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, Professor Kishore Kumar Basa, Chairman, National Monuments Authority, My Lord Honorable Chief Justice Mruganka Sekhar Sahu, Judge, High Court of Orissa and Member, Record Room Digitization Center Committee, My Lord Honorable Chief Justice Sashikant Mishra, Judge, High Court of Orissa and Member, Record Room Digitization Center Committee. May we now seek the permission of the Honorable Chair to declare the valedictory session open.
May we now request my Lord Honorable Sri Justice Mruganka Sekhar Sahu, Judge, High Court of Orissa and Member, Record Room Digitization Center Committee to kindly present the welcome address to the August gathering. My Lord, please.
Namaskar, Honorable Chief Justice Dr. S. Muralidhar, Chairman RRDC Committee Honorable Sri Justice Debabrata Das, members of the RRDC Committee Honorable Sri Justice S.K. Panigrahi, Justice Sasikanta Mishra, Honorable Justice B.P. Satpathy, Honorable Justice Sri Sanjay Kumar Mishra, my esteemed colleagues, the Honorable Judges of the High Court of Orissa and respected gracious spouses of the Honorable Judges, the esteemed Honorable former Judges, I don't find them. Anyway, Professor, since it's a prepared speech, so it usually happens so. Or maybe the first session was so much of enthusiastic response from the also. Professor Kishore Kumar Basa, Chairman, National Monuments Authority, Dr. Bhavani Raman, Dr. Amar Faruqi, Professor Partha Chatterjee and other eminent professors, and Dr. Lalatendu Das Mahapatra, Director cum Officer on Special Duty, Center for Judicial Archives and his team of consultants, researchers and staff, the esteemed discussants and the paper presenters, members of the registry led by the Registrar General High Court, other judicial officers and members of the judiciary present, esteemed faculty members and dear students from various universities, members of print and electronic media, all viewers who are present virtually watching the event being live streamed, ladies and gentlemen, a very good afternoon and warm welcome to all of you to this valedictory session of the first ever National Conference on Judicial History and Archiving organized by the High Court of Orissa to commemorate completion of 75 years of the August institution. It has been such an honor to be part of this wonderful event. Over the last 2 days, we have had deep insight into several aspects of judicial history and archiving. We are fortunate enough to have the presentations from various subject experts and also had the privilege of actively participating in 4 absorbing sessions of presentations that included as many as 12 papers. The papers presented were indeed thought-provoking and gave us insight to a subject rather less discussed as yet, that is judicial history and archiving, vis-a-vis the judicial history, archiving vis-a-vis judicial history. For me, it was a great learning experience. I would like to express sincere appreciation and gratitude to all the presenters, discussants, and the participants for very active and frank discussions, which I think have made this national conference very fruitful. We have with us Dr. Justice S. Muralidhar, Honorable Chief Justice of High Court of Orissa, who has been guiding light and the chief architect of this national conference and the Judicial Archives project. His presence is indeed a great source of motivation. Let us honor ourselves by standing up in ovation to our Honorable Chief Justice. We have with us Professor Kishore Kumar Basa, Chairman, National Monument Authority, Dr. Amar Farooqui. In my humble opinion, who yet could have been more appropriate speakers at the valedictory session. I once again welcome those who are present. Your presence has made this event a memorable one. Thank you. Jai Hind, Bande Utkala Janani.
Thank you, my lord, for the warm and heartfelt welcome extended to our guests. May we now request Dr. Bhavani Raman, Associate Professor and Associate Chair at the Historical and Cultural Studies Department at the University of Toronto, who was one of the delegates of the National Conference of Judicial History and Archives, to kindly share her experience about the entire conference. Please, ma'am.
Good morning, everyone. It's been a pleasure to be here, and I want to first of all thank the Orissa Judicial Academy and the Orissa High Court for being such warm and friendly friendly hosts, overwhelming us, I think all of us delegates were being overwhelmed by your love and your hospitality. So I think on behalf of the delegates, I must thank you for that wonderful welcome to Cuttack. There are some of us who came for the third or fourth time, and there was people like me who've come for the first time to Cuttack, and it has left such a long-lasting impression of Cuttack's rich history, of Odisha's amazing scholars, of the kinds of records and culture that Orissa is able to, I think, bring to our discussions within the historical profession, but also within the discussions of legal history. The second thing I wanted to bring up again, and this is my gratitude to the Chief Justice and his colleagues, is the warmth and openness with which they welcomed us academics into a conversation about the relationship between law and history. Over the last 3 days, we have had many discussions on the importance of law to the understandings of history, and on the importance of history to the understanding of law. This is a rich conversation, and I feel in some ways this conversation has really been grounded in the creation of the Judicial Archive and in the commitment of the Orissa High Court in making this conversation happen. So again, a very, very warm thanks for doing that. And then I think finally, you know, us historians, we talk amongst ourselves, and I'm assuming perhaps so does the judicial service, and so do the archivists. And I think that in some ways, this archive, the space of the archive, looking at these records, has allowed all of us to maybe enter into each other's rooms and maybe sit at each other's desks and tables and chairs and maybe start chatting. And I really hope that the center that will inevitably come out of this archive, I hope, will take upon itself to be a real leader and an innovator of interdisciplinary conversations. We have learned a lot, not just about Odisha history, but how to curate conversations from these 3 days. And I hope that this particular institution will take the leadership in bringing those very much urgent conversations on digitization, metadata, the richness of the file, the quality of judicial engagement in the past into our more public discussion, and be pioneers in making it part of our public discussions. Thank you so much.
Thank you, ma'am. Your presentation during the technical sessions was an eye-opener and very educative. Thank you so much, ma'am. With this, may I now request Dr. Amar Farooqi, former professor of history, University of Delhi, to kindly share his experience about the national conference being a delegate. Sir, please.
Honorable Chief Justice, Honorable Judges of the High Court, friends, the last 3 days have been, we've had a conference which is so different from the conferences or seminars that we are usually accustomed to sort of attending or participating in. And more than anything, I think as teachers, the kind of respect that we have received is something that something we are not really accustomed to. It has been the graciousness with which we have been received, the hospitality we have got, its warmth, is something that I would like to thank the Honorable Chief Justice and the hosts in the Orissa Judicial Academy for making all this possible. Yesterday we had the opportunity to visit the Record Room Digitization Center. And I think all of us were really so impressed with the systematic manner in which this whole project has been undertaken and the speed with which it is progressing. Obviously, the logistics are mind-boggling. Historians do know each file, dealing with a file can sometimes take ages for you to go through a set of documents. And to pull apart a file, take out each paper, digitize it, that's really sort of, and there's a great deal of the sheer physical labor that is involved in this was something that was on display yesterday. But there was also a professionalism with which this entire exercise was being undertaken. What impressed us perhaps most was the several levels and layers at which the verification process is taking place. Now, I think, for the historian that is important, that if you don't have physical access to a document, you should be sure that what is available is the complete file, the complete material. And in the archive, it is possible to physically sort of figure out whether a file is complete or not. But when it is digitized, thank you, when it is digitized, it actually, there's no way you can do that. And that is a responsibility which the record room, which the Orissa High Court has undertaken, and I think it is reassuring that it is being done with the kind of care that this kind of digitization process requires. I would once again thank the organizers for all that, making possible this good discussion between this interaction, people who are specialists of law, those who are engaged in the discipline of history, and archivists. So thank you so much.
Thank you so much, sir, for consenting to be part of this conference and enriching this discourse with your experience. With the permission of the chair, may we be allowed to play a short video on conservation process of fragile record in High Court of Orissa. Thank you, sir.
Conservation of fragile record. The degradation of paper material depends on the quality of the paper and various other inherent and external factors. Among the most noticeable deterioration that is recognized during the course of this examination are the following. 1. Acidic and brittle pages. 2. Tears, cuts and losses. 3. Stains. 4. Damaged spines. 5. Creases and folds. 6. Softening of paper. 7. Previous insect attack damage. 8. Damaged binding. 9. Stuck folios or pages. 10. Bleeding or smudging of ink or color. Deterioration multiplies in geometrical progression and even more rampantly. Unless treated in time, this deterioration could reach such a stage when a large part of the collection could be lost forever. There is need to undertake curative conservation of the collection, and once the condition of the collection is stabilized, a preventive conservation strategy be implemented so that the conserved collection can be kept in good health for years to come. Conservation procedure. Documentation of the record. 2. Chemical and physical examination of record. 3. Fumigation of records or pages. The records are fumigated for at least a week inside fumigation chamber with appropriate fumigants like paradichlorobenzene and thymol crystals. 5. Dry brushing of individual record. 6. Chemical conservation, consolidation and fixing of running inks. 7. Aqueous deacidification in case of sheets having non-soluble inks. 8. Double-sided lining with good quality tissue papers to impart physical strength to the record when they are in extremely fragile condition. 9. Stitching and binding of the guarded and lined sheets with conservation guidelines. 10. Treated sheet shall be kept under observation inside the conservation unit for 1 week. These conservation interventions, when carried out on a fragile record, enhances the lifespan of the record when preserved in controlled climate and under expert supervision and technical guidance.
May I now request Professor Kishore Kumar Basa, Chairman, National Monuments Authority, to kindly address the August gathering. Sir, please.
Respected Chief Justice Muralidhar-ji, respected Justice Mruganko Sekhar Sahu-ji, respected Justice Sasikantra Mishra-ji, Dr. Bhavani Raman, Professor Faruqi, very eminent scholars of history and archives, legal luminaries, young students, ladies and gentlemen. I seek your forgiveness because of my bad throat. I stand before you as a local, and how proud do I feel, and I am grateful to you, Chief Justice, for giving to the state of Odisha an archive which will have an important source for writing judicial history, which is also a very neglected branch of history. How proud do I feel as a local? I'm grateful to Chief Justice and the Registrar General for inviting me to this valedictory occasion. The main purpose of my visit is to interact with both legal luminaries as well as scholars of history. And when I see young students, believe me, sir, forgive me, the legal luminary is sitting here, the teacher in me gets the better of the chairman in me. And therefore, I should start with my experience of being a student of history. Mind you, it was 1977. I stood first in the Utkal University in BA History Honours. I was a student of MPC College, Baripada. And then I moved to Delhi University, sir. From a district level town to the national capital. And mind you, 1977, if you imagine the history of that time, it was a turmoil history. You know, just emergency has ended. The first non-Congress government has come in, and we were the students of history. And the first lecture, my friend Professor Prabhu Mohapatra is here. We are classmates. He did his MA in JNU though, but I did my from Delhi University. Professor Parthasarathi Gupta, who was teaching European history, he gave a lecture, the first lecture, I still remember. And he said, if you can answer 3 questions, you're a great historian. Mind you, a young boy from a local town, district level town, who had moved to national capital, and who doesn't like to be a big, important historian. And what are those 3 questions? The first question, he said, and it is quite obvious. If a thing has happened, why did that incident take place? That is the first question you have to answer, and that's very obvious. The second question, he said, was, why didn't that incident take place earlier? And the third question he asked, why didn't that incident take place later? Why at a particular point of time an incident does take place? And mind you, the excitement of being a great historian became mellowed down, after listening to these 3 questions. This is for my young researchers in history and also the young professionals of law, that history as a subject has to be taken seriously. History is not a catalogue of events. It's not a chronicle of facts. And as the historian E.H. Carr rightly says, it's a process of unending dialogue between the historian and his facts. Now, why the process of writing history and that dialogue is unending? It is because of two reasons. The first is new sources might come, and therefore it might lead to new kinds of history writing. That is possible. The second is, given the same set of facts, you might have two different perspectives. When you have different perspectives with the same set of data, you might come with two different kinds of history. Now, to me, sir, as far as law is concerned, I think it is also, if I'm used, you can follow Yechkar's statement, the judicial process also, to me, in my limited mind, is a dialogue between the lawyer and the judge. It's a process of unending dialogue, and the process is unending. Unending because, again, with your rich archival resources, you might come up with new examples for which the lawyer will give an argument and the judge will accept or reject or modify. Or, within the same set of law, you can interpret it differently. I think there is no dearth of evidence to that extent. I think I can just two examples, and these are very well known. For example, all of us know this 1950 A.K. Gopalan and State of Madras case, when the question was that the idea was the textual interpretation of law. At the time, the judges thought that whether there is anything written in Constitution which would debar a legislature to make certain law. And they said that no, there is nothing, there is no limit, and therefore the state can go on it, the legislature or the executive can go for the implement or enacting a clause through legislature. But that's a very textual or literary interpretation of law. But come 70s, what is happening in Kesavananda Bharati case and versus the state of Kerala 1973, all of you know. I mean, I'm a student of ancient history, so you know it better than anybody else. But you know, what is happening is, there, it is not merely a question of literary interpretation of law. It is a question of whether you are affecting the very basic structure of the Constitution. Therefore, within the same sort of constitutional limitations, the judges can interpret and are interpreting. And then also, the way history writing also changes, taking into account both the element of continuity and element of change. We historians do basically two things. They demonstrate what is the element of continuity and what is the element of change. When we talk of change, whether it is fundamental change or it is spurious change or it's a coincidence, these are the basic two issues a historian is involved with. Forgive the luminaries of historians. I mean, this lecture is not meant for you. Because you see, I'm going to the very basics, which you find that it's quite boring. But then the point to me, look at what has happened. That also happens with judiciary. We see the kind of how judiciary, within the same boundary of the Constitution. Of course, amendments have taken place, taking into account the changing scenario of society. But then the judges have done a brilliant job for us by taking into account the social changes that are being incorporated in. For example, all of us know about this attitude as far as this our approach to, let us say, this homosexuality or the other things. Yes, I mean, the justice system of this country is also taking into account the social changes that are taking place. Now, to me, that is very important. So that means the legal system of this country is as dynamic as the other aspects of the society. The legal system is not blind to the social changes that are taking place. Now, with this, let me refer to an article by Justice S.S. Dhawan of Allahabad High Court, where he has written on Indian judiciary system, a historical survey. Now, what he is doing is he has developed into 3 units, ancient, medieval, and the contemporary situation. And what he says is that, we usually tend to think that we have inherited the British system of law. Yes, that is basically the fact. Nobody denies that. But it doesn't mean that we did not have a system of justice. Now, to me, it is as important to do judicial history on the basis of the inheritance of the British system. We should also study the justice system preceding the British, before the British. That is what I feel that some emphasis has to be given. And I think some in that regard, I think Justice Dhawan has developed into 3 parts. Part A is judicial system in ancient India, part B is medieval India, and C is judicial system today. And here he is referring to the kind of very condescending attitude the colonial historians have made fun of our systems. For example, Henry Maine says, legal system of ancient India is an apparatus of cruel absurdities. Now, Alan Gledhill, he says that there was a dearth of legal principles. Now, there are so many kind of negative views as if we were in a vacuum. I'm not saying necessarily that we should celebrate everything that has been stated in the past. But on the contrary, we should not also either ignore it. So how can we trace the judicial history of India in a coherent manner right from its ancient period to the modern period is a challenge I think students of judicial history have to grapple with. The other thing, another aspect, what I can say is that we have, for example, Mahabharata, we have Kautilya's Arthashastra, we have Smriti literature, Yajnavalkya. There are where you will find the elements of justice system of our country. But there is also a problem there. In that situation, we will be quoting only the text, whatever available in terms for law. But to what extent that text were actually implemented or not, that one cannot ensure. But what is important from that is that at least we knew what is a sense of justice. Whether that sense of justice was implemented on the ground or not, what we call the difference between text and the context. So therefore, one has to see these textual references of, let's say, Kautilya or Yajnavalkya, Manusmriti, whatever the case may be. Can we get the actual sense of justice from inscriptions? Let us explore. I'm not saying that anything we will find, but in South India, so many inscriptions are there. So I'm not sure whether a judicial history has been written on the basis of the available inscriptions from South India, because in South India, thousands of inscriptions you will find. My friend Professor Rajan is sort of codifying thousands of inscriptions from temples of South India. So you are modernist, I'm an ancient man. Therefore, I'm trying to relate it whether even what we call the modern history, modern judicial history can be traced back. I'm not saying it just to push it backward for the sake of it. I'm saying that there are texts available. One can study the text, and then one can study other sources of history like epigraphy from archaeological excavations to support, contradict, modify, refine the textual sources. So the text and the context is very important here. Now, another aspect why I am interested in this archive is this is not merely getting documents of this High Court of Orissa. I presume that this should be the collecting the records from district level courts or princely states courts would be very much essential. So that will give, again, a kind of diversity within the framework of judicial history, some kind of diversity. Let's say my princely state I come from Vairvansa. So what was the sense of justice, court system, let's say Maharaja's court system, there, and then you were in Cuttack, at the time there was a High Court. So what was the difference in terms of judicial history from a princely state as well as High Court? It is another area. So what we say history from below, this is also, one can say that the history from below can be written on the basis of judicial, in the terms of judicial history. The other thing, I'm sure if we extend its scope to the district level, it will open another area of history of freedom movement of this country. Because the persons who were branded as terrorists during colonial period were mostly nationalists, or at least they were trying for Indian national movement. Therefore, the scope for reconstruction of national movement can be enhanced if we extend the scope of this archive to the district level or to the that level. From another point of view, I think judicial history is important and archive. Why? The question of governance. I think the concept of public interest litigation has brought the citizen to the gamut of law. He can challenge the state if his right to life is threatened. And when it's a question of right to life, it is not it's not a question of mere threat to life. Right to life assumes right kind of air that you breathe, right kind of water that you consume. Therefore, a broader interpretation of right to life brings into the form the question of governance. Now, therefore, to me, when we are doing judicial history, we have to deal with the question of governance. Therefore, ladies and gentlemen, and especially my youngsters, please do not think that this archive is just an archive to come and study the dusted files. This is a means to a greater end. To what extent you are addressing the question of governance? To what extent you are addressing the question of history from below? To what extent the diversity of interpretation of law are there? To what extent the threat of homogenization has been challenged by legal luminaries in terms of their judgments. Therefore, Indian judicial system is not a monolith. That is the strength of this system. And the archive and the court together now are a ray of hope for a common citizen like me, because through public interest litigation, I can knock at the door of the court of law to assert my right as a citizen for good governance. Therefore, to me, judicial history has to struggle or to make a fine blending between what we call an uninhibited dissenting imagination on the one hand and the control of the state on the other. Now, how to make a balance between the two is the real challenge the scholars of judiciary has to grapple with. Thank you, ladies and gentlemen, for your patient hearing.
Thank you, sir, for your kind words of wisdom and sharing your insightful thoughts on judicial history. May we now request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly address the august gathering. My Lord, please.
Good afternoon. I know we are closer to lunch, and I'll try and keep it as brief as possible. Professor Kishore Basa, thank you for being here with us today. Your address was really scintillating. My dear colleagues, Justice Pragnaka Saru, Justice Sashikanta Mishra, my colleagues in the audience, all the eminent historians who are present in the audience, all the law persons present in the audience, and of course our dear students. I must also acknowledge the backbone of this entire national conference, my registry, the Registrar General, all the officers, judicial officers who are in the registry of the High Court, who've been working day and night to make this conference go off without a single hitch. And I must also acknowledge, of course, the enormous dedicated workforce we have both at the Record Room Digitization Center and in the Conservation Lab and also in the museum. These are all working in tandem to make this entire project go on the right path, on the right track. I was sharing with my colleagues that in this today's last session, we should have had a small slot for presenting the work done by the Orissa High Court, at least explaining how it came about. And I think even Dr. Ashok Anshuman was very keen to know how it happened. I don't know whether this time permits me to explain the whole process, but first and foremost is the record room itself. The High Court itself is known as a court of record. You'll find that expression used even in the Constitution of India. And record therefore becomes the soul, literally, of the functioning of courts. So every court is definitely a court of record, but the High Court is acknowledged as a court of record because usually what happens, and it happened in the past, when an appeal is filed from a judgment of a trial court, the record of the trial court comes to the High Court. And in earlier days, the further filing of appeal was not a common event. It was a rarity. So today, the Supreme Court is a court of record. So if you have, for instance, the bomb blast cases of the Bombay bomb blast cases, appeals in the Supreme Court, they would have the record of the trial court. And in some other cases, they would have the record of the trial court, the High Court, and the Supreme Court's own record. So the word record is therefore so important to judicial functioning. And it is an irony that we paid very little attention to how we preserve records. We heard this morning the status of the Calcutta High Court. I must add to this, usually in a High Court building, the records are kept in the basement of the High Court. And in Calcutta, I know this for a fact, an additional allowance is given to persons working in the record room because of the dampness of the space and their vulnerability to getting respiratory problems. So this is the real state of records. I've come from Delhi High Court. Our records were kept in the basement. That is where, like this month in Delhi, that record room would be actually having water, seepages on the walls, seepage on the floor. And this is the status in most district courts as well. So I can say with some degree of confidence that having visited every district in Orissa, the record rooms were really in a mess. And I can't be surprised about it because, like I told you, even a place like Delhi, the records were neglected. Because of lack of space and no clear policy on what should be kept and what should not, there was a tendency to ignore the record room. So when I started visiting the district courts, I would first go to the record room. I would ask them to show me how the records are kept. And after the second visit to a district, from the third visit onwards, and I think that was the district where Justice Sashikant Mishra was the district judge, the buzz went around that this Chief Justice is a bit crazy. Instead of seeing all the nice things we've kept in the court, all the corridors are cleaned, everything is painted, he first goes to the worst part of the district court, which is the record room in the Malkhana. And the Malkhana is another place students of history and law should know. Malkhana is the place where they keep the material objects in a criminal case. It could be a seized dagger, a knife, a sword, a lathi, all the sacks of ganja. So there are huge amounts of ganja in the record rooms, not just in Odisha, in the district courts, but all over the country. And typically, you see 10 bottles of liquor in an excise case. Those 10 bottles have to be kept. Naturally, after 4 or 5 months, those becomes empty bottles. So these are actual experiences in Delhi also. So when those bottles are produced in court as material objects, they're empty bottles. The explanation called for, you call for an explanation, they'll say, the mice drank it. Yes. So the record room and the Malkhana, the two places judges like to avoid going to, because it's a mess. How much ever you try, it'll be a mess. So we first organized that record room. And we saw the value of that record. Because I can also share with you, when I came to this court, and this is again a practice in many high courts, a judge will simply say, call for the record. So the lawyer knows the value of these 4 words, call for the record. He knows that the case in the trial court cannot progress because the entire record of the trial court is here in the high court. So instead of asking for a stay of the proceedings, the lawyer will simply say, my lord, call for the record. And the judge will immediately pass that order, call for the record. Finished. And the case in the high court may not come up for the next 5 years, which means the case in the trial court cannot go on for the next 5 years, and so on. So one big reason for the delays in disposal of cases in trial courts, not just in Orissa, all over the country, was this 4 letters, dangerous letters saying call for the record. So one of the exercises we undertook on a humongous scale, and Justice Chittaranjan Das is the witness to that, digitizing all the lower court records which are here in the high court and sending back the records so that the trial court proceedings can go on. So this was the first exercise. When we undertook that exercise, we found the mess in our branches in the high court. There's a criminal appeal or there's a criminal revision petition, or there's, students of law should know, section 482, which is the bread and butter of criminal lawyers. There was no correlation between the case and the record. The petition would be there, but the record would not be attached to the petition. So we would come across records which is not related to anything in the high court. It is possible that the case in the high court is over, but the lower court record is still stuck with us. So this exercise helped us digitize and send back all the lower court records. We were also alive to the fact that we could lose a record. If a lower court record of a pending case in the lower court is lost in the high court, it's a big disadvantage to the parties in the lower court. Then we have something called reconstruction of records. So digitization helped us clear the, corridors of the high court, revive matters in the trial court, ensure that nothing can get stopped because of absence of a record. So we told the high court judges, if you want, you'll get a digital copy right away. If you insist on getting a hard copy, we'll print it out for you. If you say, no, I still want to see the original, in those cases, we'll call for the original. So that was one exercise we undertook in the High Court. Simultaneously, we cleared up the record rooms of the district court, the Malkhanas of the district court. And from the 3rd district onwards, after Berhampur, district judges were vying with each other to say, I want to impress the Chief Justice, my record room is better than the other record room. So it's a healthy competition. And it really helped. Even a small district like Devgarh, it's a relatively small district. I remember the way they organized their record room, Justice Das should bear witness. We circulated that video to all the districts to say, this is possible for you to do. So one important exercise is chronological, and historians should know this, chronological arrangement of records. So we had to train our staff, even in the district courts, how to chronologically arrange it so that we start digitizing from the records in a certain chronological way. So we could do simultaneously, we could pick up the oldest record, which will be the most fragile and therefore will take a lot of time. We could take a more contemporary record, which has a better quality of paper, which will take a quicker time. But we keep track of what we are digitizing and how we are digitizing. We have a separate standard operating procedure. And this has come through experience. We've been tweaking it time and again. Of course, we drew a line at 1950 to say anything previous to 1950 is fragile, will not be destroyed. So all that you see, the shredding, and some of the historians, I'm sure, are alarmed at the word shredding. It's as if history itself is shredded. But it's not true. So we can actually virtually reconstruct the record as close to the original because of the 3 levels of verification. And even we do the color scanning as you've seen in the... So these old records will not be shredded. It's only the routine kind of cases, that is the bail applications, the other routine 482 applications, and those kind of things which are filed in lakhs, those are the records. After again the 3-level verification, we're shredding only those records. When it comes to criminal appeals, when it comes to civil appeals, we have a different standard operating procedure. We preserve some of them till eternity, like a will attached in a civil court, in a civil suit which has come in appeal, that will be preserved forever. A sale deed which forms part of it will be preserved forever. So there are a set of documents, we have a separate operating procedure for that. The video here didn't, of course, capture all of that because it's a longish exercise. We created this entire department. This record room digitization center is a separate department, has a separate Abhilash's record room registrar, among other several hats he dons. But he has a whole set of officers working. We got the state government to approve this. What I'm telling you is, it just can't happen overnight. These things require a lot of planning, a lot of cooperation. If the government had said, no, we're not sanctioning these posts, we'd get stuck. We're amending the rules, the government says, no, I won't notify these rules, we are stuck. So several people have to come on board. My own colleagues who have vast experience in working in the districts as district judges, like Justice Sashikant Mishra, Justice Devabrata Das, they're all seasoned judges who've spent many years in the district. They know, they have an intimate understanding of how the district, like Justice Chittaranjan Das. So they give us inputs on what will work, what will not work, what kind of changes you need to make the rules. And this is still a work in progress. We're still tweaking, there's still trial and error. Every day in this digitization process, we are learning more and more things. And which is why we saw this as a very important event for us. As part of the 75th year of the Orissa High Court, and on 26th July we'll be completing the 75th year, we planned a series of national conferences. One was on digitization itself. But this conference, I must say, is very close to my heart. Because this interdisciplinary conference, we badly needed. My colleagues were sharing with me how much they've learned in the last 3 days. It's opened our eyes to, other issues we should be addressing. The presentation by Bidisha Chakrabarti of West Bengal Archives tells us that the word judicial should encompass all legal documents as well. We may not have all the legal documents, but we must be able to connect up those records of which may be in a revenue department, in some other department in the state, with the judicial archives, so that the historian has a complete picture of how a law originated, how a case under that law came to be filed, how did the judge look at that law, the point you made, Mr. Basa, and how did the interpretation happen, so that entire linkage can be made. So this is just the beginning. We realize it's just the beginning. We are at the edge of we are on the shore of a large body of water. It could be an ocean. But I'm glad Odisha Judiciary has made the beginning. I'm glad we've planted these seeds for the plants to grow. I'm sure they will grow in the hands of all of you and the young students here. Nurture this institution, make it grow, realize its importance, and make sure it serves historians of future generations and judges of future generations as well. Thank you for your patient listening. Jai Hind.
Thank you, my Lord. My Lord has been a constant source of inspiration for all of us, for the development of digital infrastructure of our state judiciary, and for making judicial archiving a topic of deliberation among historians, archivists, academicians, and civilians all alike. In fact, this conference is a product of that unrelenting vision. We thank you again, my Lord. May we now request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly felicitate our esteemed guest, Professor Kishore Kumar Basa, Chairman, National Monuments Authority, with a memento as a token of reverence and gratitude.
Thank you, my Lord. As we now proceed towards the end of the program, may we now request my Lord, Honorable Sri Justice Shashikanta Mishra, Judge, High Court of Orissa and Member, Record Room Digitization Center Committee to kindly deliver the vote of thanks. My Lord, please.
Vote of thanks is the last thing everybody wants to hear at this hour. And I'm sorry, I have a long list of people to thank. Kindly bear with me. Namaskar and very good afternoon to all. Dr. Justice S. Muralidhar, Chief Justice of Odisha High Court, my esteemed brother, Justice Mriganka Shekhar Sahu, Professor Kishore Chandra Basa, the esteemed Chief Guest of this valedictory session, distinguished guests, participants, ladies and gentlemen. We have come to the end of a truly historic event. The intellectual discourses of the technical sessions in the past 1.5 days were a reflection of the vast knowledge and expertise of the dignitaries and the distinguished guests in their respective fields. As we conclude, I can only say that we have all been benefited and enriched by leaps and bounds, which would certainly augur well as we embark on the journey ahead. The conference also saw the release of the much-awaited first volume of the book, The Judicial History of Odisha, which showcases the evolution of the system of administration of justice in Odisha in the ancient and medieval times, besides highlighting the customary laws of the tribal communities. The book reflects our underlying commitment to preserve and learn from a rich and varied legacy. I must also inform the august audience that the work on the next volume is already underway. Time has now come to offer our gratitude to all those who made the event successful. That the introductory session on Friday evening was graced by a sitting judge of the Supreme Court of India, Honorable Sri Justice Shripati Ravindra Bhatt, only bears testimony to the importance attached to this conference. Himself a keen student of history with flair for research, His Lordship's gracious presence added immense weight to the event. His Lordship's presidential address actually set the ball rolling for the conference, being a mix of knowledge, erudition, and an uncanny grasp over the subject. So at the outset, I, on behalf of the High Court of Orissa and the RRDC committee, offer sincere gratitude to His Lordship for his presence, insightful address, and for releasing the Judicial History book. As I said in the beginning, this two-day conference was a historic event. In fact, the first of its kind in the country. The deliberations opened up new vistas in the field of research on the hitherto uncharted territory of judicial history and archiving. I may inform the august gathering that it was entirely the brainchild of our Chief Justice, Dr. Justice S. Muralidhar. Everybody knows he is both a dreamer and achiever. It was under his personal guidance, advice, and constant supervision that the event came into being and was hugely successful. He was also responsible for reviving the efforts to publish the book on judicial history that had slackened on account of the COVID-19 pandemic. I therefore extend a deep sense of gratitude to Dr. Justice S. Muralidhar for his vision, leadership, and immense love for knowledge, which Odisha has had the good fortune of benefiting from in no small measure. Thank you, sir. I take this opportunity of informing the august gathering that the book on judicial history was conceived of and work on it begun during the tenure of Honorable Sri Justice Muhammad Rafiq as Chief Justice of the High Court of Orissa. I'm sure His Lordship would be extremely happy seeing the fruition of his dream project. I thank His Lordship for his leadership and encouragement. I would like to thank Honorable Sri Justice Debabrata Das, Judge, High Court of Orissa, and Chairman of the RRDC Committee, for his able leadership at all stages of planning for the conference and the Judicial History book, which I must inform began long ago. I also thank the other members, Dr. Justice Sanjeev Kumar Panigrahi, Justice Mriganka Shekhar Sahu, Justice Biraja Prasanna Satpathy, and Justice Sanjay Kumar Mishra for their unstinted support and constant monitoring. I also thank Dr. Justice B.R. Sarangi, Judge, High Court of Odisha, and the chairman of the previous committee constituted to oversee the work of the book on judicial history, along with the other members, Honorable Sri Justice Vishwanath Ratha, Judge, High Court of Odisha, and Honorable Sri Justice Shatrughan Pujahari, former Judge of the High Court of Odisha, for their initial directions and guidance. I thank the Honorable Judges of the High Court for their presence along with their gracious spouses, which served as an encouragement for us. I also thank the former Honorable Judges for gracing the inaugural session here in this auditorium. I thank Sri Kishore Kumar Basa, the esteemed chief guest of this valedictory session, for his gracious presence and his illuminating address. I thank Dr. Partha Chatterjee for his keynote address in the inaugural session, as also for his participation in all the technical sessions. Hearing him was truly a huge learning experience for all. Thank you, sir. We had some very renowned historians of the country acting as discussants in the technical sessions. I, on behalf of the High Court, as well as the RRDC committee, extend sincere gratitude to Dr. Suranjan Das, Dr. Prabhu Prasad Mahapatra, Dr. Nivedita Mahanti, and Dr. Sanjay Garg. Madam and sirs, your mere presence was enough to light up these sessions, not to speak of your erudite comments and observations that well and truly gave a new dimension to the deliberations. I wholeheartedly thank all the paper presenters from different parts of the country who accepted our invitation and came to Cuttack, taking time off their busy schedules to be with us and for enlightening us with their thought-provoking and intellectually stimulating presentations. Thank you, madams and sirs. I thank the officials of the state government, notably Sri R. Balakrishna, Chief Advisor to the Chief Minister, for the constant support and goodwill extended to all the projects undertaken by the High Court, including the present conference. I thank the learned members of the bar for their presence, though none is present now, but during the inaugural session, some were present. An event of this scale and magnitude would not have been possible to be organized, but for the untiring and potent efforts of the registry, so ably led by Sri Pratap Kumar Patra, the Registrar General, and his team, who literally toiled day and night to ensure the successful fruition of this event. I may be excused for singling out one individual, Sri Abhilash Senapati, the Registrar Records. He is the convener of the RRDC committee, who actually joined all the dots in the end, and the constant breathing down by us on his neck. So he, with a calm demeanor, he tolerated us. Thank you, officers, for your efforts. I also thank the Member Secretary of the State Legal Services Authority and Director in charge of the Odisha Judicial Academy and their respective teams for their support. I thank Dr. Lalatendu Das Mahapatra, Director of the Center for Judicial Archives, and the consultants, Dr. Vasant Kumar Malik and Sri Vijay Chandra Mahapatra, for their individual contributions and efforts. I thank the faculty members, research scholars, and students of the History and Political Science departments of the Ravenshaw University, students of the National Law University Odisha, and of Madhusudan Law University Cuttack for their presence in large numbers. I'm sure there would have been several takeaways for them from this conference. I thank the law researchers of the Center for Judicial Archives, Rahul Vikram Pathi, Tanuja Meghamala, and Pragya Pramita Biswal, and the staff of the High Court for acting as rapporteurs in the technical sessions. A special word of thanks for Siddhant Mishra and Srishti Samanta, judicial officers, for wonderfully anchoring the event all through. I thank our friends from the print and electronic media for their presence and for carrying the news of this event to the world at large. Finally, thanks to all the support staff and anyone and everyone who contributed in whatever measure to the success of this conference. And finally, thank you all for bearing with me. Thank you. Vande Utkala Janani.
Thank you, my lord, for your kind words of gratitude, encouragement, and appreciation.
May we now request the Honorable Chair to kindly declare the event as closed. Thank you, my lords. With this, we now declare the event closed.
With this, we come to the end of the program of National Conference on Judicial History and Archiving. I request all the honorable dignitaries on the dais, honorable judges, discussant and paper presenters to kindly proceed to the portico of Odisha Judicial Academy for a group photo session, followed by lunch for everyone in attendance. Thank you and namaskar.